Okay.
Just 1 second. Yeah, we may start.
Okay, so we may proceed. Good night, everyone. I am Gabriel Spiller, law student at the Federal University of Rio Grande do Sul, and I have the pleasure of being the organizer of today's event. The purpose of the event, as you all know, is to debate a complex legal theory topic, which is rules defeasibility. Day and night situations arise in which we ask ourselves when a rule might be defeated, how a rule might be defeated, if a rule might be defeated, among other several questions. Discussing the theme is even more relevant, taking into account that, in one hand, we are facing extraordinary circumstances, and on the other hand, here in Brazil, we're witnessing a weird phenomenon. Rules are being transformed into principles, sometimes in principles that doesn't exist, in order to be subsequently defeated, which is at least very curious. Of course, that such a relevant theme must be debated by those who are willing to study it in depth and seriousness. But when I came with the idea of organizing the event, I came across the problem that I hadn't direct access to the two ideal speakers for today's event. I knew who they were, Professor Frederick Schauer and Humberto Ávila, but I didn't have a shorter way to contact them than a pretentious email inviting them to be here with us tonight. It was in this context, completely in the dark, that I sent them the invitations asking them to join us in this event. I was aware that maybe I was aiming too high by inviting two of the most respected authorities in legal theory around the world, being an undergraduate student. But after thinking about it, I came to the conclusion that it was definitely worth a try. Then came the pleasant surprise that both professors not just answered to my email, but also accepted my invitation to join us tonight. Here we are in the presence of Professors Frederick Schauer and Humberto Ávila. So yeah, I'm sure I'm not in the position to give our audience an advice, but let it be recorded that after this event, I really do believe that everyone should send emails trying. And I imagine that this advice won't really please our speakers' inboxes, but anyway, I believe it's worth it. The first thank I have to make, therefore, is to our speakers, Professors Humberto Ávila and Frederick Schauer. Thank you very much for being here with us tonight. Accepting this invitation was a kindness from you, and I'm flattered to be here with you tonight. Organizing an event also attracts uncertainty when it comes to public acceptance, audience acceptance. You never know if the audience will return to your event with the same excitement as its organizer. But since the very first day of the announcement of this event, this issue didn't bring me any concern, as we have almost 400 people enrolled to this event from 67 universities and 7 different countries. It was truly exciting to organize this event under these circumstances. So I thank, secondly, our qualified audience here tonight. And last but not least, I'd like to thank our debater, Professor Pedro Adami, who quickly accepted my invitation to be here with us tonight. And besides from being today's debater, he also helped me with several organizational details of today's event. Besides from being this partner in organizing the event, Professor Pedro Adami is also a highly skilled professor in legal theory. He holds a master's degree under the Federal University of Rio Grande do Sul, having been mentored by Professor Humberto Ávila, and is currently studying his doctorate under the University of Heidelberg. So, Professor Pedro Adami, thank you very much. As I'm aware that the more than 300 people enrolled to this event are not watching us right now to listen to me, without further ado, I would like to pass the floor to Professor Pedro Adami, who will conduct our event tonight, renewing my thanks to our speakers, to all debaters, and to our qualified audience. Thank you very much.
Thank you, Gabriel, and congratulations for such a marvelous event. It's not easy to organize such an event with two of the most prominent legal theorists of our time. So it's a very rare opportunity to hear Professor Schauer and Professor Ávila about such an important and a theme or a subject matter that's divisibility and pandemics. We will hear first from Professor Schauer. He's a distinguished professor of law at the University of Virginia. For 18 years, he was also professor of First Amendment at the Harvard University and was previously also professor of law at the University of Michigan. He has been a visiting professor of law at the Columbia Law School, at the University of Chicago, Dartmouth College, University of Toronto, New York University, and the University of Oxford, all top-tier schools that he was a visiting and distinguished professor. He has published hundreds of works, including papers, essays, and books. His books were translated into various languages, including Free Speech from 1982, Playing by the Rules, that is almost a obligatory reading here in Brazil, Professor Schauer. Profiles, Probabilities, and Stereotypes, that is my favorite because of the creativity of the examples, and Thinking Like a Lawyer, and The Force of Law, and also hundreds of papers and articles about evidence law, free speech, constitutional law, and legal theory. Thank you very much, Professor Schauer, for being here with us tonight. We will also have Professor Humberto Ávila. He holds the chair of tax law at the University of São Paulo. He has also held the chair of tax, financial, and economic law at the Federal University of Rio Grande do Sul. And he has a doctorate from the University of Munich in Germany, and also practiced law in São Paulo. Has published many books and papers, including Teoria dos Princípios, translated into English with a foreword by Professor Schauer, into German, Spanish, and Italian. Teoria da Segurança Jurídica, translated into English and Spanish, and awaiting to be published also in German, from what I heard. And more recently, two essays, Competências Tributárias e Constituição, Liberdade e Interpretação. I also thank you, Professor Humberto Ávila, for being with us here tonight. So in our organization, we have a lecture by Professor Schauer about our subject matter, and after we have Professor Ávila that also will speak about divisibility and legal certainty. So Professor Schauer, once again, thank you very much. You have the floor, or you have the virtual floor. Thank you very much.
Thank you. I am delighted to be here, delighted for the invitation. I'm very sorry that I cannot be there in person, very sorry that we cannot do this event in person. I have many friends in many different places in Brazil, from some number of trips to various different universities throughout the country. I know many of you, especially Professor Ávila, but others as well. So let me say hello to all of you, even if I cannot do it in person. One very minor logistical matter before I start. We live in a modern world where more is automatic than we would like it to be. So if at some point I get up for about 30 seconds, it is only because the lights to save energy have automatically gone off and I must manually turn them on again. So I apologize in advance for that possibility. It's more than a possibility. I'm pretty sure it will happen. So the title of this event, the description of this event, makes reference to the pandemic. As you might suspect, other than in how it affects me personally, I know nothing about the pandemic. I know what I read in the newspapers. I know what I see on television. I know how it affects me personally. But this pandemic or any other pandemic is an area of some ignorance for me. I should mention, perhaps as a footnote to that, my grandfather, whom I never met, died in the previous pandemic in 1918. So I hope I don't die in this one. But I do know, the one thing I know about the pandemic is that a year ago, I knew nothing about it. However little I know now, a year ago, I knew nothing about it, had no idea that it was going to happen, nor did anyone else. And that's the point. How is it, and in what ways does law deal with the unexpected? That's really the topic. Defeasibility, as I will explain, is one answer to that question. It's not necessarily the only answer to that question. It is not in all systems and at all times the best answer to that question. So we should think of defeasibility as a contingent feature of dealing with the unexpected. I will explain all of this as I go along. But therefore, maybe the way to start in dealing with the question of how does law deal with the unexpected is to suggest that one way in which law deals with the unexpected is it doesn't. And in saying that, I want to go back a little bit more than 200 years, as I frequently do, to Jeremy Bentham, whose insights remain extraordinarily important, even in the face of some of his extreme views, even in the face of some of his, to put it mildly, quirky personal traits, even in the face of the fact that he is one of history's great haters. If you didn't like something and you wanted someone to hate it, that would be Jeremy Bentham. And one of the things that Jeremy Bentham hated was the common law. And Jeremy Bentham hated the common law, despite the fact that he was licensed to practice law in a common law country, trained as a common law lawyer, the son of a common law lawyer. But none of this, possibly for psychological reasons that would need a psychiatrist to examine, none of this had any effect on Bentham's sympathies. He hated law, and he hated the common law in particular. And what he hated in particular about the common law was judges. So Bentham believed that common law judges were in a conspiracy with lawyers. He called it Judge and Company, a conspiracy with lawyers to make law more complicated than it had to be in order to maximize the power of judges and maximize the income of lawyers. And indeed, one of the devices that Bentham suggested for embodying this was his proposal in an essay called Scotch Reform that it ought to be illegal to give legal advice for money. With apologies to Professor Ávila, who I gather does that now and then with some success, and to many of the rest of you, Bentham thought that it ought to be illegal to give legal advice for money because his view was that if we prevented lawyers from giving legal advice for money, we would create the appropriate incentive structure for Parliament to write very simple laws that would be accessible to ordinary people without the intervention of lawyers. Now, what makes Bentham relevant here is that he was smart enough to recognize that the real world did not replicate his ideal. So his ideal was a legal system of maximal codification. Indeed, he proposed codified constitutions for many countries throughout the world. One of the more amusing Bentham anecdotes is that at some point, when James Madison was president of the United States in the early 1800s, Bentham wrote a letter to James Madison suggesting that whatever constitution Madison and his friends might already have written, he could write a better one, and what Madison in the United States ought to do was to hire Bentham, which he was willing to do at no charge, to write a constitution for the United States. Madison did not take him up on that offer. In fact, Madison never responded. Bentham mentioned this to some number of his friends, and his friends said, well, the problem is that the United States is a federal system, and as a federal system, it has a large number of states, about 20 at the time, and each of them have their own constitutions. Bentham then proceeded to write another letter to all 20 of the states in the United States at the time, offering to write a detailed codified constitution. Again, no one took him up on this offer. But in writing a codified constitution, in proposing a maximally detailed code of laws, Bentham recognized that at times the world would throw up problems like the pandemic or others, that the world would create problems or particular events would create problems that were not dealt with even in an extraordinarily precise and detailed code. Under those circumstances, Bentham said, there ought to be a power that he called suspensive or sistative. Neither of those are words in English. I realize that most of you are not native speakers of English, although you're all fluent. Don't bother to look up those words. Bentham made them up. But they were his descriptions for the power of a judge when confronted with a previously undecided situation, a previously undealt with situation, a gap in the law, simply to suspend the law, and having suspended the law, send the whole issue back to Parliament so that Parliament could deal with the issue. So Bentham's solution, therefore, to the unprovided for case was simply to say the law shouldn't deal with it, Parliament should deal with it, the law should simply stay away. That's no longer realistic. This was one of a large number of Bentham's ideas that didn't go anywhere. Many of his ideas did. This one, once again, didn't. So the notion of saying everything will come to a halt, including the enforcement of the law, while Parliament rewrites or while Parliament thinks how to do it better, never happened. So if that's not realistic, then we find ourselves with the problem. The problem was aptly characterized by H.L.A. Hart in The Concept of Law. So Hart said that part of the human condition is dealing with the future. And Hart said that in dealing with the future, we have two problems: ignorance of fact and indeterminacy of aim. That is, we don't know what the future will bring, and we don't know what we want to do about the uncertain future when we get there. We don't know what will happen, and because we don't know what will happen, we can't decide what we would want to do when what we don't know will happen turns out to happen. So Hart recognized the problem, and in recognizing the problem of a factually uncertain future and a prescriptively uncertain future, we are faced with a familiar choice. So one choice is the one that comes a little bit closer to what drove Bentham crazy, made him so angry. One is to say that we ought to write our laws in a broad, vague, and open-ended way. So in the, at least in a fair amount of American legal theory, especially the American legal theory of private law or American law and economics, there is a familiar distinction between rules and standards. I don't like the distinction, I don't like the labels, but it's out there. But at least in that distinction, standards refer to a certain kind of rule that's broad and open-ended and vague. Again, there are terminological issues here. Some people would call these things standards. Some people would call these things principles. I prefer to think of them all as rules, but recognize that rules may be more or less vague and conversely more or less precise, and that this is a scale or a spectrum and not one or the other. But one way of dealing with the uncertain future is to have rules that are substantially imprecise, substantially vague, and therefore very flexible, and therefore easily adaptable to this uncertain future once we actually confront the future events that we could not have predicted at the time that the rules were written. So these are rules that contain things like reasonable, necessary, or, to use a word that is extraordinarily fashionable in international constitutionalism these days, proportional or proportionate, where the word itself does not give very much guidance. I've argued that it gives more than none. Some people argue that proportionality gives none at all. But whether it gives none at all or just a little bit, it doesn't give a great deal. So too with reasonable, so too with necessary, so too with some number of others. So in the Constitution of my country, we have a lot of this. Indeed, I once did this comparison that in roughly the same number of, roughly the same size print, roughly the same size type, the Constitution of Brazil is 215 pages and the Constitution of the United States is 12. When we think about constitutions that are short and vague, we can think about the United States, we can think about the Canadian Charter of Rights and Freedoms, but not very many others. And there is an interesting question that, if there's time, I can get to about why it is that nobody writes vague constitutions anymore. And why it is that the Brazilian model is much more common throughout the world than the American model. But the American model contains phrases such as due process of law, unreasonable search and seizure, equal protection of the laws, and things of this variety. Whatever we might say about those phrases, they certainly are phrases that give judges and other constitutional actors freedom to adapt their interpretations, freedom to adapt constitutional doctrine to changes that they could not have predicted. They are maximally flexible and therefore minimally predictable. That is, if you want to say to someone, especially someone without knowledge of the cases, without knowledge of legal doctrine, or someone says to you, what does equal protection mean? Or if some official, not legally trained, not aware of the legal doctrine, wants to just look at the Constitution and say, I am obliged to give equal protection of the laws. I am obliged to give due process of law. I am obliged to avoid unreasonable searches and seizures. What does that mean? It doesn't give very much of an answer. It's not very predictable. Indeed, the last of those might be the most important in the sense that the primary targets for the prohibition on unreasonable searches and seizures are police officers. Police officers typically do not have formal legal training. They are not lawyers. They know that they are obliged not to engage in unreasonable searches and seizures, but they cannot predict just on the basis of the text what courts are likely to do. They are not given very much guidance about what they should do and what they should not do. Indeed, and you might want to consider this a long footnote or a digression from what I am saying, it turns out that one of the most important and enduring exports of the United States into popular culture, right up there with Coca-Cola, is the Miranda warning. American television being what it is, people all around the world see police officers saying to suspects, you have a right to remain silent, anything you say can be used against you, and so on and so on. Indeed, there is a story, I'm not sure whether it's true or apocryphal, that goes back about 20 years of someone in the People's Republic of China having been arrested, objecting to the police officers that he was not given a Miranda warning and therefore could not be arrested. But the Miranda warning exists and is important precisely because the exact language of a Supreme Court opinion makes up for the vagueness, the indeterminacy in the constitutional text itself. A police officer who gives a Miranda warning is in effect reading from a Supreme Court opinion in ways that the language of the constitutional text itself would not allow. So that's one extreme, and I'll mention one other example. For those of you who do international law, the Vienna Convention on Treaties provides that all of its guidance, all of its rules are subject to a good faith override or a good faith clause. Good faith is like unreasonable and due process and equal protection and so on. It provides for a maximum degree of flexibility in dealing with the unknown, a minimal degree of predictability. So then we have the other extreme, precise, clear rules. And if you accept the terminology of the rules standards distinction, which, as I said, I do not, but if you accept that, then what we are talking about is the rules end of that spectrum. Precise, clear rules that are largely understandable to anyone who reads them, whether that be the interpreters or the primary addressees, precise, clear, detailed rules. So that's one extreme, and these precise, detailed rules are such that they provide maximum predictability, but minimum flexibility, and therefore minimum ability to deal with an uncertain future. So then we have arrived finally at what is, in the strict sense, the question of defeasibility. What happens when something that is precise, clear, understandable, and interpretable appears to give the wrong answer or appears to give a bad answer? Defeasibility, as I define it here, is not a function of broad, vague principles or standards. They don't have to be defeasible. They can just be adapted to whatever the circumstances demand, whatever the situation demands. Defeasibility arises out of precise, clear rules that, precisely because of their clarity, their precision, and their detail, may generate bad answers in particular cases, bad answers that could not previously have been predicted. So if I can go back to H.L.A. Hart for a moment, Hart said something important and something possibly misleading about this situation. Hart, as is well known, said that a rule with an unless clause is still a rule. At one level, that's boring. That is, one can have, depending on how one structures a rule, one can write all sorts of clear, precise rules that contain unless clauses. So we might imagine a hypothetical rule that says on a certain road, speed limit 100 kilometers per hour unless on Sunday. So that's a rule with an unless clause, but it's still a pretty clear, detailed rule, with the unless clause just a matter of how we structure the rule. There is no difference, as a matter of logic, between a rule that says no driving in excess of 100 kilometers per hour on Monday, Tuesday, Wednesday, Thursday, Friday, and Saturday, and another rule that says no driving in excess of 100 kilometers per hour except on Sundays, or unless on Sundays. They are, as a matter of content, the same rule. And because they are as a matter of content, the same rule, the simple observation that a rule with an unless clause is still a rule is trivially true. But then Hart says something that's not trivially true, that he thinks is essential, and that others, including me, might think of as contingent. because Hart then says a rule with an unless clause is still a rule, and it is so even when the unless clauses or the cannot be specified in advance, even when the unlesses cannot be specified in advance. In other words, every rule, says Hart, always has an implicit unless clause. Every rule of law at least, always has an implicit unless clause such that if we confront what we had not previously anticipated, the implicit umbrella unless clause allows us to make a change at the moment of application to deal with the circumstances that we had not previously anticipated. That is the feasibility in its strong sense. The ability of someone to change a rule in order to prevent that rule as written from producing a bad result when that rule confronts something that was not previously anticipated. Now, there are many theorists of the common law who think that the feasibility, as I have just defined it, is either an essential feature of the common law, which might be right, or an essential feature of law, an essential feature of anything properly called law in all possible legal systems in all possible worlds. That's the view of Richard Tour in a series of important articles about the feasibility. That's the view of former professor, now Judge Richard Posner. That's the view of Ronald Dworkin. It's certainly the view of Lon Fuller and most other common law trained, common law inspired legal theorists, that the feasibility is a necessary feature of law. It's impossible for me to give a lecture without making reference to the no vehicles in the park rule. So I will just remind you of Fuller's response to Hart about this. So Hart uses the no vehicles in the park example primarily to indicate that rules have a, as Hart put it, a core of settled meaning and a penumbra of uncertainty. A core of settled meaning that keeps cars, trucks, motorcycles, and things of that sort out, and a penumbra of uncertainty that leaves us uncertain about baby carriages, roller skates, bicycles, toy trucks, and so on. Fuller responds by saying, that's not right. That even in the core, the world is sufficiently uncertain, the world is sufficiently unpredictable, that there might be circumstances in which even at the core, the rule generates what looks like a bad result. And that's why Fuller uses the example of a war memorial, a statue that incorporates a functioning military truck. And Fuller says, this is clearly a vehicle, therefore it's clearly in the core and not the penumbra of the rule. But it would clearly be wrong to say that the rule should keep the truck out. And then Fuller says, it's under those circumstances where anything properly called the legal system allows its officials to avoid the absurd result by, in effect, adding an exception or adding a qualification or adding an interpretation. And indeed, that's very much what Ronald Dworkin thinks about Riggs versus Palmer. It's unfortunate that Dworkin at various different points refers to Riggs versus Palmer, that you all know, I'm sure, as a hard case. Riggs versus Palmer was not a hard case. It was an easy case that generated a bad result. It's not as if the rule, the New York Statute of Wills, did not deal with this circumstance, although it didn't talk specifically about grandsons who murdered their grandfathers in order to inherit the money. The rule seemed to contain no exception at all. And because it contained no exception at all for grandsons who murdered their grandfathers in order to get their inheritance, Elmer Palmer's murder was covered by the rule. Nevertheless, although it was an easy case, the result seems to be morally uncomfortable. Dworkin calls it a hard case only if you presuppose Dworkin's theory of law. If Dworkin is right, which I don't think he is, but that if he is right, that the legal and the political and the moral are all part of one undifferentiated whole, then this is truly a hard case. But if he's not right, and there is a distinct domain of the legal, then it turns out that this is an easy case that generates a bad result. That leaves open the question of what should happen in those circumstances. But at least I want to suggest here that it's at least plausible for a legal system to say it is better to endure, to put up with the bad result, rather than to allow a judge or some other official to decide what's a bad result and what's not. If I'm right about that, then it turns out that the feasibility in the sense that I am now talking about is contingent and not necessary. And indeed, here it's useful to be reminded of Carl Schmitt, who famously said, "Sovereign is he who decides on the exception." And if you were worried about that idea, especially if you were worried about who Carl Schmitt happened to want as a sovereign, but that's a different issue. But if you're worried about the idea that there are people out there who decide when to make exceptions and when not, and maybe it's better to put up with some bad results, you can at least imagine a legal system entitled to be called the legal system that did not have the feasibility in the sense that I am talking about. Now, a couple of things to add at this point. One, I've been talking about rules and standards, or vague and precise and so on, as if it were binary. It's not, it's scalar. It's more or less. And indeed, one way of thinking about the more or less is to recognize that making an exception also involves questions, as both Claire Finkelstein and then Luis Duarte de Almeida have argued, about the burden of proof. That is, or maybe rather than calling it the burden of proof, which is the language of procedure and evidence, we should call it the burden of justification. So maybe there are varying burdens of justification, and varying both in terms of how strong the justification has to be and also in terms of who has it. So let me change Riggs versus Palmer a little bit. Let's assume for the moment that Dworkin and the majority of the New York Court of Appeals were correct. That is, it was right, the explicit language of the statute notwithstanding, it was right not to let Elmer get the money. Now let's change the facts a little bit. Elmer is driving a car. We have to change a couple of facts because this Riggs versus Palmer occurred in the early 1880s when there weren't any cars. But change the facts a little bit. Elmer is driving a car. His grandfather, Francis, is the passenger. Elmer is driving too fast, and unbeknownst to his grandfather, has had a few drinks before getting behind the wheel of the car. So driving too quickly, and with the assistance of a little bit of alcohol, the car goes off the road, and Francis, the grandfather, dies. Elmer is still the beneficiary of his grandfather's will. Should Elmer be allowed to recover? Now the case is not so clear. It's a little clearer in the real case, because after all, Elmer intentionally murdered his grandfather, poisoned him in order to recover. Now Elmer is merely negligent, grossly negligently responsible for his grandfather's death, but didn't intend it. Does Elmer recover? Does Elmer inherit under the will? Again, there's no right or wrong or no clear answer to that question, but one might plausibly say, as indeed a number of American courts have said, that it was right not to let Elmer, who was a murderer, inherit. But anything short of intentional murder, even if the beneficiary is responsible for the death of the testator, does not put aside the will. So my hypothetical negligent Elmer recovers, even though the real murdering Elmer did not. All of that suggests that much of this may be a question of how much does it take to defeat. If the feasibility is about defeating a rule, there is a question of how much does it take to defeat the rule, which is not all or nothing, and is the rule, who has the burden of showing that the rule should be defeated, and with what degree of justification. So a few things before I finish. I want to draw a distinction that's useful as we think about all of this between internal defeasibility and external defeasibility. Internal defeasibility is the defeat of a rule because the purpose of the rule is not itself served. So Fuller's example of the military memorial, setting aside the rule, is internal defeasibility. That is, the whole point of the no vehicles in the park rule, whether it be noise or safety or anything else, is not served by keeping the statue memorial out, and therefore something internal to the purpose of the very rule itself is at issue. By contrast, external defeasibility might occur when the purpose of the rule is served, but something else suggests that the rule still ought not to be applied. So think of the classic example of someone rushing an injured person to the hospital, and in the process of rushing an injured person to the hospital, drives at 140 kilometers an hour where the speed limit is 100. Here, the purpose of the rule is violated. It's not safe to drive 140 kilometers an hour. No matter how sick the person in the back seat is, no matter how important it is to get the person to the hospital, it's still unsafe. the purpose of the rule to maximize safety is being served by sanctioning the person who's exceeding the speed limit. But there's another thing that also comes in from the outside, which is why I want to call it external, that says it's not a good idea to let people die rather than rushing them to the hospital quickly. So this external factor overrides the rule, even though the purpose of the rule is not being violated. One final thing that your introduction suggested to me, and I'll mention this and then I will stop. One way of thinking of the feasibility, as you properly suggest, is as a way of rules being converted into principles. Rules being converted into standards or whatever. It turns out that that's clearly right, but also it happens in the other direction as well. So when we see rules that are written in broad, vague, open-ended terms, a common phenomenon is that judges who believe that the broad, open-ended, vague, flabby, fuzzy rule is too broad, open-ended, flabby, and fuzzy to be predictable and give guidance, will add specificity so that there will be more predictability and more guidance. The Miranda warning, the Miranda rule is one of those things. We see it in various other areas of law throughout the world. That because clear, precise rules are often too clear and too precise and too rigid to deal with an uncertain future, those in charge of interpreting those rules will often make them looser and vaguer than they are when they are written down. But when they are written down as broad and loose and vague, the same interpreters, thinking that those broad, vague, loose rules give too little guidance, may add additional rules or sub-rules or interpretations that make them more precise. So it turns out that principles incline towards rules and rules incline towards principles. And although this may vary from system to system, at some point there's less of a gap between the two than we might think just by looking at the rules or just by looking at what's written down. And with that, I will recognize that one of the rules that I think is important is the rule about not going over one's assigned time. And I would much rather listen to Humberto Ávila than listen to myself. So with that, I will stop and thank you for your attention.
Thank you very much, Professor Schauer, for this brilliant lecture. We sure learned a lot, and we have a lot to think about. I for sure have a lot of questions I would like to ask, but we, as well as you, I'm also wanting to hear from Professor Ávila. So, Professor Ávila, you too have the virtual floor. Take as many time as you want. Thank you very much.
Good evening. First of all, I would like to thank Gabriel Spiller and Professor Pedro Adrami for the invitation. I would like to congratulate Professor Schauer. I'm very happy to see that he is in very good shape. Clearly and convincingly, as always. I won't talk too much, but I will say something about this, the feasibility of rules. Of course, if you have to face the subject, the feasibility of rules between legal certainty and exceptional circumstances, we should define the meaning of the feasibility, the meaning of rules, the meaning of legal certainty, and of course, the meaning of exceptional circumstances. but I will make it differently. I will read an article of the Brazilian Constitution, Article 57, paragraph 4, which says, the re-election to the same office in the immediately subsequent election being prohibited. It's a rule about the directing boards of the Chamber of the Deputies and the Federal Senate. I will repeat, the re-election to the same office in the immediately subsequent election being prohibited. Well, we have a recent decision of the Brazilian Supreme Court, 6 votes against 5. And 5 judges said, read this expression, re-election being prohibited as being permitted. So my question is, following the words of Professor Schauer, is there a vague, obscure, and unspecific rule, or instead a precise, clear, and detailed rule? Second question, faced with a previously undecided situation? Third question, have we uncertainty about the facts and indetermination of aims? Fourth question, was the re-election unexpected? And the last question, is the solution unreasonable or obviously bad? No, no at all. We have a precise, clear, detailed rule, a decided situation, certainty about the facts, determination of aims, expected solution, and a good one, because it's for the sake of democracy. Why 5 judges read prohibited as being permitted? How can this happen? So my point is, I would like to answer 2 questions. First question, is there a rule? And the second question is, if there is a rule, is this rule defeasible? If yes, under which circumstances? So the first question is divided in 3 minor questions. The first one, is there a prescriptive meaning? The second question is, which meaning? The third question is, convey this meaning a rule or a standard? So the first one is there a prescriptive meaning? So here we have, depending on the option we make, we have a theory of meaning, and on the one side, we have radical contextualism, which says that the meaning depends on the context. It's not only defined in the context, but is defined by the context. That's radical contextualism. On the opposite side, on the other hand, we have pure semantics or insensitivity semantics. And the principle, the so-called principle of compositionality, says that the meaning of an expression is determined by the meaning of its parts and the manner in which they are arranged. So we have 2 opposite schools. The second point of view is the relation, not the between the meaning and the context, is the relation between the subject and the object of interpretation. So we have, on the one side, a radical skepticism. I could remember the words of John Gray. The courts put life into the dead words of the statute. So we have dead words. They don't say anything. There is no meaning at all. But the courts will assign the meaning of the dead words. And on the other side, on the opposite side, we have formalism or cognitivism, which says that the meaning is already given and the subject has just to reveal this meaning or to recognize a prior meaning. Well, my point is, if we accept a radical contextualism and a radical skepticism, there is no meaning at all. There is no meaning. So, the only way to have a prior meaning is to choose pure semantics or moderate contextualism, or a moderate cognitivism, which says, for example, that we have a frame with some possible meanings, but the meaning can't be given by the subject who is interpreting the object. Well, and of course, when we adopt radical contextualism, we are saying that meaning is use, just use. And it depends not on the semantics or the syntax, just on the use at a particular situation. Well, but if we accept some semantical theory of meaning and a kind of moderate formalism, we have to face the second question: which meaning? And in this case, we can divide into two topics. The first of these topics is the following. We have to use the conventional meaning, which says that a meaning have semantic autonomy or is a contextual regarding to a particular situation, or we have to choose something else, like an intentional meaning. An intentional can be a state of mind and can be, of course, a presupposed intention of a group or of an assembly. My point is, if we adopt an intentional theory of meaning, a psychological oriented analysis of intention related to a particular person, we still don't have a meaning. We can find it as we can find if you adopt a conventional meaning. But still, if we adopt a moderate contextualism, a moderate cognitivism, and adopt the conventional meaning of the words, we have a third question. Conveying this meaning a rule or a principle? This question is important because depending on the definition of principle, principle is a norm we can balance against another norm and give priority to one of them against the others. So here we have two opposite understandings. On the one hand, a structural distinction between principles and rules. A rule is a norm that makes direct reference to a behavior, and a principle is a norm that makes direct reference to a goal. And we can find it analyzing semantic and syntactic elements. On the other hand, we have another orientation, which I call the pragmatic distinction between principles and rules. It's not a problem of semantics or syntactics. It's a problem of use. I said before, meaning is use for somebody. I'm saying here, norm is use. So for example, if I sit in this object, it's not a book anymore, it's a chair. And if I write with my pencil here in this object and read it, it becomes a book. There is no book and no chairs. There are objects used as books and chairs. So, returning to our point, there are no rules and principles, just norms used by the interpreter as a rule or as a principle. So, my point here is, if we accept a pragmatic distinction between principles and rules, we don't have rules. So, repeating, if we accept a radical contextualism together with a radical skepticism, together with a psychological oriented analysis of intention, and together with a pragmatic distinction between principles and rules, this subject we are talking about, there is no sense about talking about the feasibility of rules, because there is no rules to be defeasible. There is no certainty, and there is no object of exception, just because there is no meaning. And this meaning is not prescriptive, because this meaning can be construed, can be modeled by the interpreter, the one who should play by the rules or should obey the rule. He makes the rule. So why I'm saying all of this? Because this subject matter, the feasibility of rules, is a very important one. But in Brazil, I don't know in the United States, but in Brazil, we are going to the wrong direction. So if we accept these orientations, we just don't have rule of law. We have rule of men. We just don't even have a rule. It's just men's decisions. We don't have legal certainty. We have legal uncertainty, or not even legal. we have just decisions of men without any prescriptive orientation. So my feeling is that this theoretical foundations of interpretation and meaning are the problems we are facing in Brazil. How can we explain, for example, that we have in the Brazilian Constitution, Article 148, the union may institute compulsory loans to make extraordinary expenses resulting from public calamity. It's there. How can we justify that some judges of the Brazilian Supreme Court use public calamity as a reason to modify the meanings of clear, precise, and detailed rules? So if you don't face these theoretical foundations and choose some in between, so a moderate contextualism, the meanings are not bricks, they are not sand, perhaps sandy bags, perhaps modeling clay, but certainly not sand. If you accept a radical skepticism and face the legal provisions as dead words, we just don't have meaning. So my proposal is, I think Professor Schauer defends disorientation, as we can see in his famous book, Playing by the Rules, or in the old article, Formalism, from 1985. We have to adopt a conventional meaning and see somehow, at least in the public domain, some acontextual meaning in the legal provisions. But the second question is the following. If there is a rule, is this rule defeasible or not? So here is another problem. The first question is the presupposition of the subject matter. If we choose some orientation, we cannot discuss this subject matter. But if there is a rule, is this rule defeasible? Well, my point here is this. We have here also two opposite directions. On the one hand, we have a radical formalism. We're not talking about theory of interpretation. We're talking about rule application. It's another thing. On the one hand, radical formalism. And on the other hand, pure particularism. So again, if you choose a pure particularism, there is no rule at all. Again, if you decide just to decide one case at a time, one case under the particular circumstances, we don't have a rule. So, of course, I follow some theory very related to the presumptive positivism defended by Professor Schauer, with different words. But the first point I think we have to answer is the following. Is there a specific rule about the specific circumstances? Because if we have a rule, there is no legal gap. And we have an answer from the legal system. So these two examples are very easy examples. These cases are easy cases. Why the first one to decide the first one, we had 5 votes saying that prohibited was permitted. How can we explain that? How can we explain the second problem here, that we have a detailed, specific, and clear rule about public calamity, but the public calamity is used all the time by the judges to interpret the legal, the constitutional provisions differently from the conventional meaning. Well, so I think here again, we cannot adopt a pure particularism. And we have to answer two questions, I think. The first question is there a specific rule about the specific circumstances? If yes, we have to follow the rule. Because in this case, just to repeat, in this case, we have a rule, we have a decided situation, we have certainty about the facts and determination of aims, we have an expected problem, we have a reasonable solution. The second question is, which kind of rule? That's an interesting problem, because sometimes we are facing the application of a rule that restricts the fundamental rights of liberty, property, and equality. It's different when we face a rule that doesn't restrict these fundamental rights, but do the opposite. And the third question I think we have to answer is, if we decide that the rule is defeasible, are there systematic effects, not for that rule, but for the system of rules? Because if you have this problem, we cannot make this rule defeasible. So I think that interpretation involves humility and respect. We don't have too much from the interpreters. And I think if you don't have this, we don't have a rule. And this subject matter, the feasibility of rules between legal certainty and exceptional circumstances, makes no sense, because there is no rule to be defeasible, there is no certainty, and there is no object to be object of exception. So thanking again, I return the word to Pedro Dani.
Thank you very much, Professor Ávila. It was a very interesting and provocative lecture. I'm sure we all have some problems with this decision that you mentioned of our Supreme Court, but I think Professor Schauer can probably understood the problem that there is an very, very detailed norm or a rule that says that they should not be elected, or they cannot be elected, and somehow 5 judges interpreted that they could be elected. You know? But it's something that maybe comes with the tradition or the culture of the Brazilian legal system, and somehow I cannot see that belongs to the nature of rules, that somehow they can be in such a manner interpreted. Professor Schauer, if you want to make some comments, you.
Okay, so just, so nothing I have heard in the last half an hour is anything that I disagree with. I think Professor Ávila is right, but let me just add a few footnotes to that. One, he said in describing the question or issue about being permitted and being prohibited, I don't know what the situation is in the US, but this is the way it is in Brazil. So in the US, to use the modern slang expression, that ship has sailed. Or to put it perhaps more accurately, that ship sailed in 1798. So let me give an example. The 11th Amendment to the Constitution of the United States, not very important in the grand scheme of things. I'm going to read it in its entirety. The judicial power of the United States, that is federal courts, the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. That is, the 11th Amendment says as clearly as it can possibly be read or said, that a citizen of a state cannot in federal court sue another state. The American courts, the US Supreme Court, for 150 years have said that the word another means another or same. That is, that particular provision prohibits a citizen from using the federal courts not only to sue another state, but also to sue his own state. That is as contrary to the text as prohibition and permission. And that's widely accepted by many people, not by me, but widely accepted. Let me give another example of the same phenomenon. Back in the 1980s, when Guido Calabresi, one of the great figures in American legal theory, early theorist of law and economics, early theorist of the common law, when he was dean of the Yale Law School, wrote a book called A Common Law for the Age of Statutes. And in this book, he argued that the modern world is changing so quickly, and legislation in the United States is so difficult because we don't have a parliamentary system, that very often the laws on the books are obsolete. They're out of date. And he suggested when laws are out of date, judges ought to have the power, the text notwithstanding, to update out-of-date laws to make them current and useful. What's especially interesting about that is that 3 years later, Calabresi found himself as a federal judge in the United States Court of Appeals for the Second Circuit, sits in New York. Aside from the Supreme Court, one of the two most important courts in the United States. The fact that he took that position, or that he wrote as he did, was no obstacle to becoming a very important, prominent, powerful federal judge. So when I say that ship has sailed, it may be that despite the efforts of some number of people, American law has for a long time been quite anti-formal in precisely the sense of formalism that I use and Professor Ávila used. Now, there are objectors, and the objectors don't come from all parts of the political spectrum. I, with no power, am an objector. The late Justice Scalia, with a lot of power and politics very different from mine, was also an objector. So there are defenders of formalism in the US, but we have a degree of anti-formalism that might be somewhat comfortable for many people with understanding prohibition as permission. Indeed, if we think only about the United States Supreme Court, one of the things that the political scientists who study the Supreme Court and study the votes of the Supreme Court with cutting-edge quantitative methods have concluded is that the best predictor of the vote of a Supreme Court justice is that justices' political and ideological and attitudinal views about the issue, and that that's a much better predictor than what the law actually says. Now, that's not so much true in lower courts. It's not so much true in many of the state courts, but at least for the Supreme Court, which doesn't decide very many cases, and they're all important because the Supreme Court can decide what to hear and what not to hear. It turns out that attitudes, ideology, a whole bunch of things matter more than what the law as it is written down. Many of us think that's unfortunate, but many commentators think whether it's unfortunate or not depends on what the outcome is, which is also unfortunate. Let me say just a few other things in response to the many ideas in what Professor Ávila was saying. One of the things he was talking about, although he didn't use exactly this language, was the fact that rules cannot determine their own application. That's pretty much an idea from Wittgenstein, that you need another rule about how to interpret the rules or what the rules will mean. So the classic example, whether you can see this or not, if you see this on the road, do you go this way or do you go this way? This does not tell you whether to go to the point or whether to go to the tail. You need another rule to tell you how to interpret this arrow. Whether we call it formalism or anti-formalism or contextual meaning or literal meaning, all of the rules about what kind of meaning are determined by other rules. And I share Professor Ávila's hostility to total contextual meaning. And indeed, it's worthwhile mentioning here that in the philosophy literature, especially the moral philosophy literature, there is a counterpart. It's what is known these days as moral particularism. Probably the most important figure is Jonathan Dancy. And Jonathan Dancy's views are that moral decisions are made only case by case without the benefit of moral rules. I think that's descriptively wrong and prescriptively unadvisable, but the position is out there. So let me end with one example, more recent than anything that I've written about on this. It comes from a US Supreme Court case about 3 years ago called United States versus Yates, Y-A-T-E-S. So the underlying law was a statute passed in the wake of some of the financial scandals of 15 or 20 years ago with Enron and all of this. The Sarbanes-Oxley law. And one of the problems in the Enron scandal was that once the federal authorities were seen to be coming close, the officials of Enron did what any of us would do with approaching federal officials looking to look at our records. We shredded all the documents, or they shredded all the documents. This was discovered, and worrying about this became part of the Sarbanes-Oxley law that made it a federal crime to destroy, initially, to destroy a document in order to prevent it from being used in prosecution. But as the law was being discussed in Congress, people said, document is too narrow. What about hard disks? What about floppy disks? What about hard drives? All of these kinds of things. So the law was changed to prohibit the destruction of any tangible object, to prevent it from being used as evidence in a criminal case. All of this was about financial misdealing and everything else. So now we jump ahead a few years. Mr. Yates was a fisherman. He's out on his boat all by himself. He's a commercial fisherman, but he's out by himself, all by himself on a boat fishing for grouper. There are laws saying that you cannot keep any grouper that you catch that's smaller than a certain size. I suspect that there are similar laws in Brazil designed to keep the stock of fish vibrant so that you can't keep fish that are smaller than a certain size. A federal official whose job was to monitor these kinds of things was out there in the Gulf of Mexico, observed Mr. Yates bringing in fish that seemed to be too small. The federal official approached Mr. Yates in his boat and said, "Let me look at those fish." Yates shows him the fish. Federal official says, "Those are too small. You're in trouble. Put those fish right here in the cooler or whatever. I will be right back with one of my associates and we will pick them up." At that point, we can guess what Mr. Yates did. He immediately threw all of the undersized fish back into the Gulf of Mexico. This was also observed by the federal official, whereupon Mr. Yates was prosecuted for violating the Sarbanes-Oxley financial records law by throwing a tangible object, a fish, away, destroying a tangible object in order to prevent it from being used in a prosecution against him. In a 5-4 decision, this case went to the Supreme Court, possibly because they had nothing better to do, but maybe because they found it amusing. This case went to the Supreme Court, which by a 5-4 decision decided in favor of Mr. Yates. Said this law was about financial records. This law had nothing to do with undersized groupers. Regardless of what the literal language of the law said, you cannot be prosecuted under this statute. And there were 4 dissenters. Interestingly, the 5-4 decision did not align along expected political grounds. The literalists included Justice Kagan, left of center, Justice Scalia, right of center. So there was no common political alignment, but the non-formalists won, and the formalists said, this is what the law says, you broke it, that's it, that, lost, but by 5-4. So I'll end with that example and send it back to you.
It's nice to see that some things just change the address. They happen both countries.
Yeah,
Very
right.
similarly, yeah. Professor Ávila, if you have any comments, or we can start just a small exchange. I have a couple of questions, and it's for both of you, and maybe it's more of a provocation than a question. Since the rules are made for normal times, Professor Schauer and Professor Ávila, could we say that a global pandemic or extreme situations or a public calamity is an external factor that overrides the rule's purpose or the legal system purpose, so to speak, since they are written for normal times? And in that matter, it's wise, even though it's not an essential feature of the law, it's wise that in this case we recognize a wider margin of discretion for the decision makers. Since rules are traditionally made for normal times, abnormal times can be themselves, just that we're living in abnormal times, be a sufficient external factor to override the rules application, or we maintain the formalistic view in order to gain legal certainty, even though the rules are made for normal times. Yeah. And
who first?
You can go first, and then Professor.
Okay, so I think I want to resist the question, or be provoked, or however you want to describe it. That is, I think partly there is the question of who decides what's normal and what's not. And it comes back to the sovereign is he who decides on the exception. But I also want to press against just what it is these days to think about what is normal. So let me just talk about the 20th, not 21st, 20th century history of my own country. In the 20th century history of my own country, we were involved in a world war from 1914 to 1918, although the US was not involved until the last few years, but a world war from 1914 to 1918, and another world war from in terms of US involvement, 1941 to 1945. We had a catastrophic financial depression from 1932 until 1940. We had the excesses of the anti-socialism, anti-communism, and the like of the McCarthy era from 1948 to 1952. We had the enormous civil unrest in the 1960s and 1970s of the civil rights movements and anti-Vietnam protests. So even in my own country, and even for that 100-year period, I'm not sure there are many periods during that time that one would want to call normal. We may be living in a period of perpetual abnormality. And if we are living in a period of perpetual abnormality, I'm not sure what it means to say that the laws are written for normal times.
Well, I would say the same. when the law is obsolete, or when the law, when there are normal times. Who decides that? That's the problem. So my concern here, I can give an example. This Article 57, paragraph 4, was written in 2006. 2006. And it's a very precise, clear, and detailed rule about the subject. And the constitutional provision says being prohibited. So I think there is a great distinction between the Brazilian constitution and the American constitution. Our constitution is much larger, of course, but for example, this article was written in 2006, not hundreds of years ago. So there is another thing here. And Professor Pedro Adame asked about this in the external factors. I will give an example. There is an article in the Brazilian Constitution which says that municipalities can tax the property. And there are some conditions to tax the property. The municipality has to know if the property is used as a commercial item or a residential property. Well, the point is, in the pandemic of coronavirus, the commercial shops should be closed. So the properties couldn't be used. So the point, they have to pay the tax or not. I would say something a little bit different. In the philosophy of language, we have some differences between what is said, what is meant, what is done, what is implicit, what is implicated, and what is presupposed. Presupposed. If I said to Professor Schauer, I'd like to visit United States again, that's because I've been there before. So again presupposes my earlier visit to the United States. So the point is, this article that says that the municipality can tax the property presupposes the use of the property. Is that an external factor or an internal factor? I would say internal factor.
Okay, thank you very much, Professor Ávila. It's of course I do not agree with my question, so it was only to provoke a thought. So I'm very happy to hear this answers. I don't know if Gabriel, if you have any questions. We almost 2 hours already, and Professor Schauer and Professor Ávila probably a little bit tired. And if you don't have any questions, we could wrap it up. And
okay, we could wrap it up. For me, no problem at all, for the sake of family, you know.
Yeah. So once again, I would like to thank Professor Schauer. Thank you very much for your time, for the generosity to speaking with us here in Brazil. We certainly learned a lot. We have a lot to think about. And Professor Ávila, once again, thank you very much for being with us. It was very lovely. We learned a lot. We also have a lot to think about, even though we can be sad when we think about our Supreme Court and some of its decisions.
So,
Gabriel, once again, congratulations for putting up this event. It was a marvelous evening. We sure learned a lot.
And thank you very much. And I look forward to seeing you soon, hopefully in Brazil.
Yeah. We have invitations. Okay, thank you very much, and bye-bye.
Bye.